sorry to interrupt. Colleen Clace, and also with me is Valley Goss on behalf of the victims in the underlying criminal matter, Paul DeHouteville and Mary Peachin.
Okay, thank you. I didn't mean to ignore your appearance.
No worries, and I apologize for interrupting.
That's okay. Are there any other appearances? Okay, hearing none. This is the time set for a Rule 26D conference, and we're also going to address the joint request and certification of readiness for setting a settlement conference. We'll start with the what I'll call a joint statement of discovery dispute. It seems that the claimant takes the position that the state of Arizona is delinquent on its Rule 26.1 disclosures. So let me hear from the claimants first.
Sure, Judge. This is Peter Lamperis. Since we couldn't attach exhibits to the 26D, I thought it may be helpful just to fill in maybe some of the blanks in terms of why we have this concern specifically. And so the real issue we're having, and the reason we're asking you to order them to produce a fully compliant disclosure statement as quickly as possible, is we have a looming deadline on August 28th for late witnesses, disclosure, expert witnesses, and so on and so forth. We filed this on January 1st. We did a notice of claim on October 31st, 2025, at which time I presume the Attorney General would have started collecting documents in order to evaluate the notice of claim. So this has been around a long time, and they've known they're going to have to obtain records to defend the case. We produced in our initial disclosure on April 13th, 97 pages. We produced 9 gigabytes of exhibits. The state gave us an 8-page disclosure statement with no witnesses, no exhibits, no documents, nothing. And the email we got, the cover email to that disclosure, was from a paralegal at the Attorney General's office. And she said that, and I'll just paraphrase it unless you want me to read it directly, that we're not disclosing these documents because we just think it'd be more efficient to talk to you on the phone. We'll compare what we have with what you have, and then we'll sort of figure it out from there. Once we're able to do that, we should be able to give you a witness list, was the response to that initial disclosure statement. We coordinated with them to get them all of our exhibits digitally, which we did shortly thereafter. By April 28th, I started wondering, where is this disclosure statement? I asked them, when do you expect we will receive your initial disclosure statements? I get no response. A few days later, we give them our first supplemental disclosure. 3 weeks after that, on May 26th, Mr. Leader, my co-counsel, asked them, where's the disclosure? We've been asking about this. Where is it? We get no answer on where the disclosure is. You did your scheduling order on June 3rd, so our hope was, okay, they're going to adhere to the scheduling order. These are more or less the dates you adopted from theirs as opposed to ours. So I assume they understood that they would be able to meet their obligations under that scheduling order. June 15th, we give them our second supplemental disclosure statement. Mr. Leader asked them again, where's your disclosure? And asked for a meet and confer. We get an email from the AG's paralegals saying, hey, we haven't forgotten about you. We'll reach out to you within the next couple of weeks. The next day, June 17th, Mr. McWright emails us and says, look, we're severely understaffed. We don't have any documents that you don't have. There's no disadvantage to your client. We ask for your patience, and there's no reason to take this to court. We give them another 3 weeks, thinking, okay, we'll continue to be patient, but it's getting pretty tight. July 10th comes around, still nothing. So I asked for a meet and confer 7.1, which we do, and that leads us here. So the story that we've received from the AG has changed over time, and I'm not sure what the actual answer is, but it's gone from, we don't have any documents you don't have, let's confer with you, we'll figure out what we should disclose, which of course is not anything the rule permits. We've lately heard that, well, we're trying to, and we saw this in the 2016, we're trying to get these documents, but we're having a hard time. We don't have them yet. Those entities might want to do their own work product review. These are things that should have been done probably in late 2025. Certainly it should have started right away in January of 2026. And the notion that we shouldn't bring this to the court and there's no disadvantage to Mr. Taylor, who's been waiting most of his adult life to try to get some semblance of justice. And when we have a deadline coming up in 2.5 weeks, 3 weeks, we can't figure out what to tell our experts. We can't figure out who to notice for depositions. We are shooting in the blind, and we're unable to proceed with this case in an appropriate and timely fashion under your scheduling order. We think it's unfair that their answers are that they're severely understaffed, that they don't have any documents. We don't have, none of those are in the rule. That's not an excuse that's permitted by the rule. And we ask you to please direct them to immediately disclose. 10 days would be better at this point as opposed to 14. A fully compliant disclosure, and that, if they don't, we'd like the opportunity to seek Rule 37 sanctions and severe ones. We're just left in a situation where we cannot properly proceed, and it's unfair, fundamentally unfair to Mr. Taylor. Thank you,
Okay.
Judge.
Ms. Rubacek?
Thank you, Your Honor. As presented by counsel, it certainly sounds like the state has not done due diligence, except that that's simply not the entire story. The original offense in this case is over 40 years old. That standing alone means that many of the relevant records are now in archives, in warehouses, in various locations, in both, I believe, Pima and Pinal County. That's the information that we have. It has never been the Attorney General's office that was the prosecutorial agency on the case. So to the extent that it is the state, it's simply not the Attorney General, and we are having to reach out to other entities. And this particular case has been handled by both the Pima County Attorney's Office and I believe the Pinal County Attorney's Office, as well as the concurrent civil suit that is currently proceeding in federal court, which has created additional concerns, cautions. It is also curious that counsel is advancing that his client is somehow prejudiced when attorneys on the other side have been involved in this case for over 15 years. And I feel quite confident, have more documents than we have or may ever have. So certainly they have the documents. In light of the fact that there's tens of thousands of pages of potential disclosure, our thought was to have what we described as a disclosure conference, which admittedly is not provided for in the rules. But as the court is aware, this statute is in many ways blazing new ground. I don't know that there are many other circumstances in Title 13 where we're proceeding under the rules of civil procedure. We've not met resistance in our other cases where we have suggested this to try and limit poor use of resources and duplication of disclosure that we would talk about. Okay, do you have this minute entry? We have these pages of this transcript. One of the things that Mr. Lamperis mentioned was the initial disclosure. We were advised in preparation for receiving disclosure that it was going to be 7 terabytes of information. And not being tech savvy myself, I had no concept of how huge that is, but it is enormous. And on our end, to even be ready to do that, we had to purchase separate equipment, make arrangements with the information technology folks, not only here in Tucson, but also in Phoenix, figure out how we would integrate that to our system. It was quite an undertaking. Then we finally did what we needed on our end to be able to receive that. There was some back and forth between our paralegals and the support staff at Mr. Lamperis's office to get that transferred, and it turned out to be much less than 7 terabytes. So that wound up being effort that was made in good faith that ultimately may not have been necessary. We are understaffed, and I know counsel is quick to discount that, but the reality is you have 2 attorneys, both of whom have other full-time assignments, working all 12 of these cases, which are new at every turn. Mr. Taylor's is not standing alone. We're trying to resolve other cases. We, as the court may know, were involved in a special action proceeding regarding notice of claim under the erroneous conviction statute, which required attention. So we are doing the best that we can with all of that. Also, there was, for a period of time, mention made by Mr. Taylor's attorneys that they may be interested in pursuing a settlement. And so we proceeded along that path for a period. It appears that may be unlikely within the rubric that had previously been discussed, but certainly that was the focus, was trying to resolve it. And when it became apparent that wasn't the case, we have reached back out. The Pima County Attorney's Office, when we contacted them, advised that they were no longer in possession of the files they believed we were seeking. They directed us to private counsel, who is the same counsel representing Pima County in the federal matter. We've been in contact with them. My understanding is earlier this week, I think we finally received what they have in their possession. So we are in the process of reviewing to verify if there's anything that is being withheld as work product or alternatively subject to redaction. So we are working on that. And again, complicating this case in particular in a way that is not true of other cases, there is a lengthy history related to the 1983 litigation in front of Judge Marquez. And while the argument may be made that, well, that has nothing to do with this, that's simply not true. They overlap to a large degree, so it is necessary to proceed with extra caution here to avoid inadvertently somehow running afoul of something that has happened in the federal case, to which the Attorney General is not a party. So we're having to essentially play catch up and review the record to see where are we at, what's happening. Mr. Lamperis will be able to speak to this better than I, but last I knew, that matter was set for trial in September. I don't know if that has changed. So not only is the erroneous conviction litigation somewhat overwhelming, this particular case has a number of additional factors that require a bit more time, a bit more caution, extra review, contacting additional parties. It is not unique to this case. We are having some difficulty, some resistance, sometimes simple misunderstandings around requests we are making of other agencies for their files, and we're having to go back sometimes 2 or more times to clarify. That has occurred certainly as we're trying to handle this case. It is not that we are not trying or not complying or not aware of our obligations. It is that we are proceeding cautiously as we are required to do, that there have been some setbacks necessitated by communications and in some cases miscommunications, it appears, between the parties. We will be providing what we have as soon as we've completed our review. We're hopeful it'll be the first part of next week. And it is just difficult to understand how it is that claimant feels he is prejudiced when the true stance of this case is that he is in a much more advantageous position as relates to history, documents, other litigation than is the state. But nonetheless, we are doing what we can to try and advance the case. And once we have a better handle on what actually is out there, because we can't force these other parties to produce things, we can only ask there will be a point at which, if they choose not to, subpoenas may be necessary. But we are doing what we can. And Mr. Taylor is dissatisfied that it's not proceeding at the pace he would like to see. But to the extent he's concerned about things like disclosure deadlines, we're more than willing to discuss any continuances that he may feel are necessary to preserve his ability to prosecute this case.
Okay, let me address the issues. I recall from the outset of this particular proceeding that the state filed a motion to have the rules of civil procedure applied, and that's what the statute provides. And so Rule 26.1 imposes obligations on all the parties to the proceeding, and I'm sympathetic to the understaffing issue, knowing the number of these cases that there are, and these are being handled by a relatively small unit of the Attorney General's office. But the sympathy only goes so far, because the legislature created this special type of proceeding, and it seems that it contemplates a kind of a expedited process here, and maybe somewhat aggressively, but I think I adopted, as Mr. Lamperis said, the state's proposed scheduling order in large part, and we have an upcoming deadline for dispositive motions, and we have an evidentiary hearing set, an 8-day evidentiary hearing set on April 26, 2027. So there are things that need to be done to move this forward. I'm also sympathetic to the issue that the Attorney General's office needs to obtain information from archives in various agencies, but it likely needs to be the case that the state makes rolling disclosures as it obtains the information from the various agencies. And certainly there ought to be some sort of a disclosure at this point or sometime very soon of witnesses with knowledge and so forth, even if the state is still obtaining documents from the various agencies. So it sounds like there's going to be an initial disclosure, at least, Ms. Rubicek, within the next week or so. Is that what you're anticipating?
Well, to be clear, we did make our initial disclosure. It was admittedly general, but it made reference to every matter in the procedural history. I am of the understanding that we do actually have some documents now that we will be able to disclose. It is, again, my understanding that Mr. Taylor and his counsel may already be in possession of them, but we'll send them over. And we are in the process of trying to determine what exists, where it exists, who has it. It's just been difficult because of how many proverbial cooks have been in the kitchen on this one.
I understand. I am going to set a deadline for a supplemental disclosure by the state, and I'm going to require that in 2 weeks. So that's going to be August 21 will be the deadline for a supplemental disclosure. If the state is still gathering information, then it will need to do additional supplemental disclosures, but what the state has now will need to be disclosed within 2 weeks. So that'll be the deadline for that. And my hope is that we don't need to have a Rule 37 motion to compel, but if there's non-compliance, then the claimant will be authorized to file such a motion. I'm really hopeful that that does not become necessary. And I understand, Ms. Rubicek, that you and Mr. McWright and the other people in your division are doing the best you can. So
thank you, sir.
Go ahead.
I just said thank you, sir. We are. It's proven to be quite an undertaking. So we appreciate the court's understanding very much.
Okay, let me turn to the joint request regarding the setting of a settlement conference. And it seems that the complicating factor, based on what I read, is the claimant insisting on some non-monetary terms of any settlement, and the state not being in a position to be able to agree to those. And I mean, I'll tell you, my inclination at this point is that it may not be helpful for me to require the parties to go to a settlement conference. What's your view on that, Mr. Lamperis?
I think it can't hurt. I mean, we've all been to settlement conferences where we were convinced, or the mediator was convinced, that a settlement wasn't going to be possible for one reason or another. And you just never know until you get all the parties together. You talk frankly about things with a mediator. A neutral party goes back and forth. Things can happen. And, you know, from what I'm hearing from the AG in the 26D, and for all these months and today, you know, it's a lot of work and so on and so forth. Why wouldn't we all give it a shot? It seems to me that's a missed opportunity.
Okay, I'm not privy to what the non-monetary terms that are creating the issue for the state, but Ms. Rubicek, what's your position on this?
Judge, obviously, if we are ordered to settlement conference, we will go. What is unusual here is that the statute provides certain types of relief that the state is not in a position to necessarily just grant. Or concede. It's an unusual statute insofar as which entities do what. And as to this particular case, we believe that some of the non-monetary relief is not appropriate. Again, if you order us, we will go. My only request on behalf of the state would be that Mr. Taylor himself be required to be present. And I appreciate that if he needs his guardian with him, that's fine. But I think it's important that he also be involved in the proceedings. Again, if he needs his guardian present, that's fine, but so that he's has the opportunity to hear everything that's going on.
Okay, Mr. Lamperis, what about that?
That's fine with me. Mr. Taylor's been there, as counsel has noted, there is another case going on. There have been other settlement conferences, and he's always there.
Okay, I don't have the scheduling order in front of me. I'm assuming that I included in that a deadline for the settlement conference to take place. Is that correct, Mr. Lamperis?
You did. I think it was mid-September, if I'm not mistaken, Judge. But I'm not positive without looking at the scheduling order. Let me see. I don't have the scheduling order in front of me, Judge. So that's just my recollection, is that it was mid-September, but I'm not sure.
And did it specify that it was going to be a private mediation or a judge pro tem, or what was it?
So my recollection on that as well is that we prefer private, but the AG indicated that it did not, and I believe you adopted theirs. I can probably pull it up if, give me a second, Judge.
Excuse me, this is Stanley Feldman. Peter, there's a clerk's order. The judge assigned it to the clerk to set an order, and the clerk set an order for private, not for private, for a judge pro tem, I think. But there's an order from the clerk.
Okay, thank you. Let me just.
Yeah, and you're on.
Go ahead, Ms.
I see.
Rubicek.
I'm sorry. I see that here. It appears that issued. June, and we are settlement conference no later than October 30th, it appeared.
Okay, I see that. I pulled up the settlement order. So now the problem here seems to be the form of certification that's required under the ADR rules. Is that what's creating some of the position here too, that discovery and disclosure, for instance, has been completed to where you can have a meaningful settlement conference. So, Mr. Lamperis, I'm assuming that you're of the opinion right now that you can't make that assertion.
Yeah, I mean, that's why we tried to figure out how to use the form in a way that was efficient and told you something. And so we did our best to sort of put in our respective positions.
Here's the problem with that. I usually don't review these. They go to the ADR part of the court admin, and if you don't follow the form, I'll get a request that I issue a minute entry saying it's non-compliant and calling off the ADR settlement conference. So here's what I'm going to do on this. I don't know what your deadline was to be able to have the ADR settlement conference to get this certification in. So I'm going to affirm the requirement that the settlement conference take place. You may need to confer about modifying the scheduling order to put out that date so that you can get the disclosures that I've ordered, Mr. Lamperis, before you make the certification.
Okay.
Okay, but for now, I'll require that the parties attend a settlement conference, and as the state requested and as the claimant has agreed, Mr. Taylor will have to be attending, and that may be with his guardian. Okay?
So Judge, a scheduling order adjustment to the August 1 date, which was the deadline for the Rule 16, meaning push that up to late September or something like that?
Right. You may have to do that, and then that will mean putting out the settlement conference date because the ADR section of court admin needs a certain amount of time to get a judge pro tem appointed after you do your certification. So you may need to push out that October 30 date for completing the settlement conference.
Thanks, Judge.
Okay. I do have another hearing coming up in a couple of minutes, so I think that resolves the issues we had on the calendar. Thank you for appearing today. Have a good weekend.
You too.
Thank you.
Thank you, Judge. Thank you.
This is CV 2025-009-271 Tahir versus Donka et al. I'll take the appearance for the plaintiff, please.